Today I'm going to break down the most common driving offences in the UK. Some of them are strict liability. What is strict liability? What are the possible defences? I will also explain as we go along in each offence. Driving without insurance. Here, believe is not a defense. So if you believe that you had a valid driving insurance and at the point of questioning you did not manage to show that you had a valid insurance, that is it. So the prosecution doesn't have to show anything else other than where you have failed to show or produce a valid driving insurance. This is governed by Section 143 of the Road Traffic Offence 1988, and this is called a strict liability offence. So, as I mentioned, prosecution do not need to prove your intention. The fact that you didn't have, that's all they have to prove. In terms of defense, there is few defenses that you can talk about, but let's talk about first what kind of points you're looking at. There's 6 to 8 points, that penalty points that can be endorsed against your license, and under Band C you can get some fines for this depending on your situation and financial position, and if there's any aggravating factor the fine can go up. The possible defense could be that you genuinely thought that you were not driving on a public road or a public place, you were driving on a private path, you were not the driver. That could also be another defense that you can say, and you thought the insurance actually existed while you were driving. So that means if you can show there was an administrative error, then that possible defense can also be. Sometimes you can also show an alternative insurance, like your employers covered you. That is again very limited in scope, but you can use that as a defense to show that you did have a valid driving insurance while you were driving the vehicle. In terms of the solicitor's involvement in this type of cases, a solicitor will go through the policy wording. The solicitor will also look for MID database regarding what kind of evidence they have about your license or insurance company, and they can also challenge whether you were actually driving on a road or a public place. And sometimes under the mitigation circumstances or mitigating circumstances, special reasons to avoid disqualification can also be challenged or argued by your solicitor. Driving while disqualified. Now, this carries an instant prison. I'll tell you why. Because you see, when you drive being disqualified already, you are violating a direct court order, and the court is not happy when you actually come back to the court while driving under being disqualified. So it's a flagrant violation of the court order. You are sometimes, most of the time, looking at a custodial sentence. So first find out what are the possible reasons that you can expect to get away with this offense or not get to prison. The first possible answer would be you were not driving, that you were not the driver, that was not you who were driving on that day. So therefore you basically have to show that you were somewhere else, or you were not the driver, someone else is driving. You have any supportive evidence to prove that you were not the driver, and then that is a good defense for you. In some cases you can also have a defense that you were not aware of the disqualification, but this is a service of notice defective notice of service. Your solicitor will try to find out how that decision disqualification was served on you, and those terms will be challenged. And sometimes in some emergency reasons, or you were under duress when you were driving, that could also possibly be defense, but then again they are very limited in scope, and sometimes the court will not accept that argument. But most of the time, the only way you can actually get away possibly from a possible custodial sentence is depending on your mitigation circumstances. So if the mitigating circumstances actually does balance on the balance, it shows that it would be harsh not only on you or maybe your family, then sometimes, or how remorseful you are, and sometimes the pre-sentencing report, which is produced by the probation service, which I'm going to talk about in more detail later on in this content, can also be a factor which can save you from custodial sentence. But mind you, this is one of those harsh offences whereby for these driving offences you can go to prison. Let's talk about drink and drug driving. Okay, so this is the thing. It's not about what you think you were feeling or how you feel and that you did not go over the limit. That's not a defense. As soon as the alcohol consumption or the drug is found on your body, has gone over the limit, that is it. You are convicted of that offense. Now, in terms of defenses, these are very difficult in scope. Most likely you're looking at 12 months disqualification and fines, and sometimes potential imprisonment, obviously depending on the aggravating factor and what mitigation you can actually produce to the court. But this is also which can lead to a prison sentence. In terms of possible defenses for drink and drug offences or driving is procedural error. You can show the defective breath analysis or breath test procedure or the results. If you're a lawyer, obviously, when they have access to common law platform or CJSM, they actually get the documents which CPS has against you or the forensic report. That sometimes can be challenged. So that is a potential defense, but that is not a given case that every time the police has conducted the breath test or the actual lack of continuity in taking samples, that can be challenged. Medical reasons sometimes can also be a factor, that the alcohol in your body or the whatever the level of the drugs that was found in your body was induced by some medicine. That is also a factual evidence-based defense that you can basically rely on. A post-driving consumption is sometimes also something that can be challenged, but like I said, these are very limited in scope. So the solicitor will mostly look into the procedure and custody records, how the whole breath test was conducted, and if there's any technicality or procedural error, he will try to basically use that as your defense. That brings the admissibility challenge of evidence that was taken against you or used against you for this offense. So that whole admissibility can also be a good defense. The mitigation circumstances comes very handy here. So the reduction of the charge or reduction of the penalty, depending on your mitigation circumstances, can also be very useful as defense. Driving without a license, as simple as it gets, it is a criminal offense. Make no mistake, some people do believe it is not a criminal offense. It is, and for many reasons you can have this offense, like you were driving without a supervisor, without a L number plate, without an expired driving license, or with a provisional driving license, all of which basically will constitute the offense against you. So if you are basically under those circumstances, the defense that you can produce becomes very limited. Possible defense for driving without a license could be you had the license, it existed, but you failed to produce at that point. Reasonable excuse, that is also very limited. There is not much you can do to show that there was justification for you to drive when you didn't have or carry a valid license. A misclassification of license category, that can also be a possible defense, but then again that's very subjective. So we discussed all the common driving offences in the UK, but now let's talk about what's the legal procedure, how those offences end up in court, and what can you expect through the legal procedure until you get a sentencing or non-conviction from the court. Let's find out. When the police stops you, then basically they stop you and search your vehicle. They can question you. Police can actually ask you to do breath test using breathalyzer, and then they do some roadside checks of your vehicle, or they take reports of the incident. They can at that point also take reports from other people who actually witnessed that incident. So that happens. And after that, you do get notice of intended prosecution, which we call NIP. Now, for careless driving, reckless driving, or speeding, you can expect to get that notice within 14 days of the offense. Sometimes the police can just simply say, look, this is your first offense. We would offer you to take some tests, some tests which will give you more idea about speeding and whatnot. And they offer you a certain penalty, but that doesn't create any criminal record. However, if you do get the intended notice of prosecution and also section 172, whereby they are asking you to basically give the details of the possible vehicle owner, that if you are going to be charged, then you will get a postal requisition. So that postal requisition whereby police can charge you, and then you can get the single justice procedure, which we call SJPN. That postal requisition will give you basically information the police wants you, or the prosecution, they have referred that offense, and the prosecution now gives you a date and the court basically requires you to attend the day on the court. Here, you will also be given an opportunity to make a plea, either you plead guilty or not guilty. So let's hear what happens when you plead guilty or not guilty. So you see, when you plead not guilty, that triggers a different sets of procedure. So when you plead not guilty, obviously you have to attend the court, plead that I'm pleading not guilty. The court then sets a trial date. And then basically after the trial date, I'll come to the trial date procedure, and after the trial date, then go to the sentencing period. But what if you plead guilty? So if you plead guilty, obviously you can notify the intention on paper. Sometimes they say you don't have to appear on the court. A sentencing will be delivered to you if you plead guilty. But in some cases, even if you plead guilty, the court may require you to attend the date at the court. So when you go there and plead guilty, the court can either directly go for sentencing on the same date, or fix another date whereby sentencing will be given. And at that time, sometimes the court may request probation service to prepare what we call pre-sentencing report. So this pre-sentencing report, the probation service will interview you, will try to gather information about you, your finance, your situation with life, your family life. And the probation service's job is to recommend a sentence for you when you plead guilty. So they take all of this information onto account, and then they recommend suggest the court that this should be appropriate sentencing given your situation. The court do take that into consideration, although the CPS may quite naturally request for higher punishment, higher penalty, higher fine, but sometimes the court has to come to a balance between the pre-sentencing report and the request from the prosecution for the appropriate sentence. At that point, even if they're sentencing, you have an opportunity to produce your version of the facts and your mitigating circumstances. So here, you and your solicitor is trying to explain to the court what actually was the behind the facts, what happened, why it happened, why this should be taken into consideration, why compassion should be given, and if you are remorseful, what actions have you taken, what steps have you taken towards it. The court can take into that consideration and give you a lower fine, lower penalty, and lower penalty points. So however, end of the day, if that's a sentence, that would create a criminal conviction, criminal record in your file. If you plead not guilty on the first hearing, all the cases starts from the magistrate's court. The magistrate, like I said, will set a date, and your solicitor, before the trial, through the common law platform, the CJSM portal, will basically analyze all the evidence from the prosecution service, their witness, their statements, their forensic report, any mechanical data, whatever information they have produced, and your solicitor will have an opportunity to produce your part of the story, your side of defense, your documents using the same platform. Here, your solicitor's job will be to analyze those documents and find out if there's any fault or defect in prosecution's case, and at some points, on many occasions, if your defense is strong, the prosecution may basically drop the case altogether. There will be basically discontinuations report given. That means they are not going to continue with your case. So before trial, your solicitor also may request attendance of certain individual, so police officer who stopped you, police officer who was involved, or other victim, or other people who has given evidence in favor of the prosecution. Your solicitor has a right to cross-examine them. So likewise, prosecution also have the ability to question you, and after all that, the judgment will be given, the sentencing will be reserved. In some cases, if it's in Crown Court, that's a different story. In the Magistrates Court, the magistrates may retire and come back with a sentence. And then, accordingly, the sentence will be endorsed, the points will be endorsed. If there's a custodial sentence, you will be taken to custody. These are the procedure once the NIP starts and you are charged with an offence and until the date you are sentenced. If you think this discussion is beneficial to you or someone, do share and like, and leave us your comments if you want to know more about certain topics. I would be interested to know, and in the next episode, in the next segment, we will try to come back and answer some of your questions. But thank you for listening.